I believe that he quit working whenever he moved in with his girlfriend, and that he started a GoFundMe to pay my bills and take care of my little man with a goal of $20,000.
Welcome back to court, and buckle up, because today's hearing is a masterclass in how evidence, credibility, and employment history collide in child support law. On one side, mom says dad used to make solid money setting tile. Think $5,000 a month when work flowed, and now he's watering plants at $15 an hour. On the other, dad claims a slowdown, layoffs, and a tough job market. The judge, laser focused on one question. Is he intentionally underemployed to dodge child support? Expect pushback on hearsay, a hard line on proof, and a reality check on how courts treat cash jobs and GoFundMe claims. Watch closely for 3 pivots. 1. What counts as evidence? 2. What proves intent? And 3. How guideline support gets calculated when income drops. Who's right legally and who just feels right emotionally?
$1,000.
All right. So in the interest of time, basically, do you agree to finalize temporary order as is regarding everything, including the child support, medical support, dental support judgments, the health and dental insurance with the cash medical and cash dental payments per month, the non-disclosure and the court cost and the court cost, all that except for the current child support as is?
Yes, sir.
All right. So let's moving on to what's actually contested. What, as far as you're aware, what is his current job? Mr. Haldeman's current job?
He waters plants or works at a tree place.
All right. And so what is the last job that he had that you're aware of?
Setting tile.
All right. And so when did he work at this setting tile job?
He's worked with that since he was 15 years old, off and on, but here in Texas, recently, 2022.
All right.
So
and
2024.
All right. So so how much do you think he made setting tile by 2024?
At least $5,000 a month, if not more.
All right, real quick, ma'am. Were y'all together when he was doing this?
Yes, Your Honor.
All right, and did he tell you that, or did you see a copy of his pay stub?
He told me that, Your Honor.
All right, thank you. You may proceed then, Mr. Welch.
Thank you, Your Honor. Do you have any documents or anything that say that, he had this job and was making that amount?
No, Your Honor, or no, sir. I think he was being paid under the table, or I don't know how it works. I don't know if you got.
All right, that's it. That's good, ma'am. That's good. Do you have anything else you'd like to tell the court?
This is a pivotal legal moment. Mom believes dad earned approximately $5,000 per month setting tile, but she admits she has no pay stubs and suspects he was paid under the table. In family court, belief isn't enough. Documents rule. When income is disputed, courts weigh tax forms, 1099's W-2s, bank statements, contracts, invoices, or employer testimony. Under the table raises red flags, but without corroboration, it's tough to convert into a support figure. Editors, flag this for viewers. Would you impute income here or not? Comment below. If someone claims higher past earnings but can't show records, should a judge lean on prior lifestyle or stick strictly to provable numbers?
That the only reason that the child support was suddenly lowered is not because he contacted the court. It was because I finally contacted the court for non-payment. He didn't suddenly say, oh, I don't have a job, and contacted y'all to lower it. He just quit paying whenever he decided to do that. And then I had to contact the court to get involved.
Pass the witness, Your Honor.
All right, ma'am. Do you know the last? What's the last date that you're certain that he was actually working at putting down tile now?
May or
Huge
June.
distinction coming through. Mom says child support got suddenly lowered only after she contacted the court for non-payment, not because dad responsibly reported a job loss. Legally, that's the split between modification, changing support going forward, usually tied to current provable income, and enforcement, chasing, missed payments arrears under the existing order. Non-payment is not, by itself, proof of intentional underemployment. Intent needs evidence. Viewer question: if a parent stops paying and only later surfaces with a lower wage job, does that feel strategic to you or a real-world economic hit? And more importantly, how would you prove which it is?
May or June of 2024.
Okay. So it's been more than right now. We're looking at what 13, 14 months on 14, 15 months on that right now. Okay, thank you. And do you know who he was working for?
His brother.
And I'm sorry, did you just lose touch with it, or did you know that he left his brother and was no longer doing that? What's the circumstances revolving around that, ma'am?
At that point, we weren't really communicating, and I wouldn't believe anything he told me. He didn't tell me.
All right, then. So the first time you heard about the current job he has at this point, ma'am, when did you hear about that?
Sometime this year.
Okay. Before the first meeting at the AG's office?
Maybe.
Okay. All right, ma'am. I'm going to let the state call the other witness, and then I'll come back to you. And I'm sorry. Is there anything else, ma'am, in these circumstances that you can testify to, that you're eyewitness to, or that he told you that would confirm that he's intentionally underemployed?
Yes. I believe that he quit working whenever he moved in with his girlfriend, and that he started a GoFundMe to pay my bills and take care of my little man with a goal of $20,000. And I don't believe that that is.
All right, ma'am, stop. Did he tell you that, or is that something you researched on the internet yourself?
I researched it on the internet because my brother contacted me. Yes.
Okay, here's the deal, ma'am. That's hearsay. All right. Even though you found it, you saw it, you're testifying to it, you have no way. Did he tell you that? Did he actually tell you himself that he set that up?
No, but I have a photograph, and it says Daniel Haltman is the one organizing it.
Okay, here's the deal, ma'am. That's still photographs, images. That under law, they're hearsay. You got to verify that those are true and correct as far as what they are and who set them up. All right. I know you're not a lawyer, ma'am, but I can't. If I was in a courtroom today and I tried to show a picture in court of something, I would have to show that I had to get it ruled as proper evidence to come in. All right. And that's just the way we work, ma'am. I'm sorry.
Yes, Your Honor. Is it possible to ask him if he did that?
Well, I'll ask the state to. The state can ask him, and you can ask him as a question, man, going forward. But again, it's kind of that still doesn't show that he's intentionally underemployed.
Okay, well, he has.
Judge's hearsay tutorial matters. Internet screenshots, like a GoFundMe page, are not self-authenticating evidence. Unless a party admits ownership or you bring a witness like records custodian who can verify authorship and accuracy, it's hearsay and likely out. Even if admitted, a GoFundMe doesn't prove intentional underemployment. At best, it shows financial distress or messaging. Editors, emphasize this rule for the audience. If it isn't authenticated, it isn't evidence. Strategy note for pro-SC parties. Convert online claims into admissible proof. Subpoena records, get platform confirmations, or secure testimony. Viewers, would you have guessed a public link isn't automatically
He's looking for another revenue source.
Well, I don't believe he went to any job interviews. I think he just quit and found a job as soon as the court contacted him.
Okay, ma'am. But again, unless he told you or you're an eyewitness to that information happening, you cannot testify to that. Okay, you may believe it, but that doesn't make it so, man.
Right.
No, I see you thinking about it, but again, I know you're not a lawyer, and that's why I gave you the opportunity to go out and get a lawyer that can do this correctly, man. But again, right now, if you're before the court asking the court doing something, you or he, I got to hold you to the same standards as if you were you graduated from UT Law. All right, sorry.
Yes, Your Honor. I did contact a lawyer, and they told me that he wasn't disabled. He shouldn't have
I'm
it.
sorry, ma'am. You can't testify to that. You're talking about hearsay upon hearsay. All right. So, I'm sorry, ma'am. I get it. Believe me, I have people in here all the time who want to try to represent themselves. And I get lawyers who don't get this right, okay? Because I get the objection to hearsay all the time from other lawyers, and I have to sustain that objection, okay? Because they're trying to get hearsay in. But it is what it is at this point. So I'm going to go ahead and let the state call the father as a witness, and then we'll get his testimony. And I'll allow you to ask him questions, ma'am, but they got to be pertinent and relevant. And again, not that he's looking for another source of income, that he intentionally left his job to really technically to lower his child support, ma'am. That's pretty much it. And I'm sure the state's going to go into that with him right now a little bit too. But for right now, ma'am, I'll let the state call the father as a witness, and then we'll come back to you. And then again, at the closing, you'll be allowed to do a closing argument, a statement, ma'am. Anyway, at this time, Mr. Welch, I'll go ahead and let you call Mr. Altman. Thank you.
Thank you, Your Honor. State calls Daniel Haltman. What is your full name?
Daniel Sean Haltman.
All right. Now to get the other stuff out of the way. Do you agree to essentially keep the temporary order as is for the final order?
Yes, sir.
All right. And so let's talk about your income now. Where do you currently work?
At A+ Line Landscaping.
All right. And how much you make per hour?
15.
All right. Do you have any other jobs?
No, sir.
Do you have any other sources of income coming to you?
No, sir.
All right. Is what Ms. Haltman said accurate, that you have a GoFundMe account?
I did start one. Nothing came of it, but it was due to me being jobless for almost 4 or 5 months. I was looking for work. I couldn't find anything over $50.
All right, that's it, sir. So when was the last job you had prior to this lawn place?
With my brother setting tile.
So how much did you make at that job?
It varied because work varies, of course, in construction. But when we were doing a lot of work and working good, I was making about $5,000 a month.
All right. And so when did you leave that job?
I'm not sure the exact date, but it was around May, maybe.
May of this year or last year?
2014.
Wait, May of 2024 or 2014?
2024, I'm sorry.
All right. And so why did you leave this job?
We got laid off as a crew. Work was slowly decreasing. We were getting less and less work.
Dad testifies. Tile work via his brother as subcontractors under a flooring company. Workload slowed. Crew laid off around May 2024. Months of unemployment. Now at A+ Landscaping for $15 per hour. The legal question is not, could he make more? It's, did he deliberately choose to make less to cut support? Construction markets do fluctuate. Crews get trimmed. That alone doesn't equal intent. What would shift this? Evidence that jobs at or near prior pay were available, and he knowingly refused them, or that he staged his employment change around the child support process. Viewers, does his timeline sound plausible or conveniently
less
timed?
work because the way construction worked. And eventually there wasn't enough work for them to keep all of their crews going. And we were the ones that got unlucky.
So I guess I'm a little confused. So you work for your brother,
Yes, sir.
but you two worked on a cruise. So
We
can
were
you explain how that worked?
subcontractors. We were subcontractors through a company called Chisholm Trail Floors. Chisholm Trails got jobs, sold tile and our services essentially, and gave us the jobs, and we tiled the jobs and they paid us. And that slowly decreased until we were eventually let go.
All right. So when's the last time you've tried to, go for an interview for a job that's more closer to what you did before as a tile layer?
I had looked for more tile jobs online, and
When was the last time you went to an interview or did something, sir?
I hadn't gone to no interviews. The A plus is the only interview I actually went to.
When's the last time you applied for like a tile laying job?
I don't think I've actually applied. I searched and nowhere paid more than 15 an hour. The only reason I was making as much as I was is because I was employed through.
All right. Why haven't you been trying to actively go out and find something closer to what you've been making before, making good
Critical
money?
admission. No applications for tile jobs and only one interview, the landscaping role. Courts often look at reasonable efforts, applications, interviews, outreach to prior contacts, using trade boards, showing rejection emails. Without that paper trail, some judges consider imputing income, assigning earnings based on prior skills, job market data, or earning capacity. But here's the catch. To impute, you still need reliable labor market evidence or a vocational assessment. Editors, highlight for the audience. Do you think a skilled tradesman should be pushed to prove an exhaustive search? Or is a stagnant market explanation
To what you've been making before, making good money?
Because there isn't any. I'm not going to be able to set tile.
All right, that's it. So what is your highest level of education?
High school diploma.
Do you have any special licenses?
No, sir.
All right. So before this tile, so how long were you doing this tile laying?
On and off since I was about 14, 15 years old.
All right. Have you had any other jobs before, I guess, before the latest tile laying stuff?
No, just contract construction, like some framing, some drywall, just construction jobs.
And the last construction job you did, when was that?
It was with my brother.
Well, when, sir? I don't need exact dates, sir. Just general.
It had to be back in May, maybe even before that.
So back in May 2024?
Yes, sir.
All right. And so how much did you make from that kind of job?
It just varies on what the job was. We could make anywhere between $600 to $3,000, $600 to $3,000, depending on what we were doing on that job particularly.
And I guess when you mean 600, $3,000, that's like per job, or is that how like?
Yeah, that's per contract. Yes.
All right. Do you own a car?
No, I've been driving my girl's car to work and back.
All right. You own any real property?
No, sir. I signed it all over to Miss Haltman per her request.
All right. That's it. That's it. Did you file for income taxes last year?
No, I had everything taken from me. I couldn't do anything, and I never got a.
All right. That's it. That's it. That's it.
No. I'm gonna let me answer that one. Sir,
Yes, Your Honor.
did you get a 1099 or a W-2 last year?
No, sir.
All right, thank you. You may proceed then.
Yes, Your Honor. Thank you. Do you have any documents or something saying that, you were laid off from this tile laying job?
No.
Pass the witness, Your Honor.
All right, sir, you mentioned earlier that from the time you were laid off until you got your current job, I'm not sure your current job, you say you were looking for employment for about 4 months.
Yes, sir.
All right. Then you were independent contractors, so
No 1099, no W-2, no layoff letter. That absence weakens both sides in different ways. For mom, it makes historic earnings harder to prove. For dad, it muddies the layoff narrative and undermines credibility on income volatility. Remember, the burden to show intentional underemployment typically lies with the party alleging it. If the record is thin, courts default to what's verifiable now. Practical tip for viewers in similar situations: keep tax forms, invoices, text-email threads with contractors, bank deposits. They can win or lose your modification case. Question: should judges penalize cash-heavy trades more when documentation is
independent
spotty?
contractors, so they weren't. So you're supposed to be a 1099 employee, correct?
Yes, sir.
All right. So no unemployment or anything like that was paid to you.
No, sir.
Okay. And what county was this operation in?
Believe Coriel.
Okay.
McLean.
And does your brother still have is your brother still doing the same thing, or has he moved on to something else?
He has moved to San Antonio and is doing something else.
Okay. And the entire time you were doing this tile work here, was that in this general area, or was there somewhere else? I'm talking in the last 3 years. That 2 years you were doing this job with your brother. Was that local, or did y'all ever travel?
It was kind of all over the Central Texas. We'd go all the way to like Moody and Waco and just wherever the work was.
All right. Well, I can't, anything within everything was within a 60-mile radius of where we are right now, right?
Yes, sir.
Okay. All right. Thank you. All right. Any other questions, Mr. Welch?
No, Your Honor.
All right. Ms. Hartman, here's the thing. I'll go ahead and allow you to ask the witness questions, but you got to run them through me first. Again, you're a layperson, and I just need to see whether or not they're relevant and appropriate. So at this time, ma'am, you can ask the question, and sir, don't answer it until I say it's okay. Ma'am, you may go ahead and start, please. Thank you.
I guess as being the skilled laborer, that he would be able to maybe find some better employment. I don't know if there's a job search company or something, but he has the skills and he should be able to make what he was making.
All right, here's the deal, ma'am. Does he? I'm gonna ask you. Do you know of any special licenses or education that he has for this, or just or anything along those lines, ma'am? Certifications, anything?
My understanding is in the state of Texas, you don't need to be certified to do most
I know that, man. I know that, but I'm asking you, do you know whether or not he has any type of certification, something that
not to my knowledge, Your Honor.
All right, man. All right, ma'am. Right now, I'm giving you the opportunity to ask him a question about from his testimony, or to elaborate on his testimony. Do you have any questions?
Is there a reason why you didn't go and do more job searches? You said you just looked online, but you didn't actually go apply anywhere.
Objection, Your Honor. I think I already asked that question earlier.
Okay. Let me run something by sir. You testified earlier. You did this online, man. Pretty much everybody does everything online now. You don't go out and pound the pavement. You go online, try to find anything. What did you use as far as your online searches, sir? What would you recall? What the Was it Indeed? Was it Zip Recruiter? What did you use, sir?
I got ZipRecruiter. I think I got Indeed too. Like I went and did the recruiting apps, and I'm still getting emails about like stalker jobs, but they're all $15 or less for those.
Okay, but
So
the jobs that you were doing, they were specifically for tile workers, construction work.
I tried that, and nowhere's hiring for tile because tile is slowed down substantially since the economy's changed.
And you've always worked for someone you did not. You were never an independent contractor on your own. Is that
Yes,
correct?
sir.
All right, ma'am. Give me your question again. Because again, it really wasn't a question. So go ahead and try to give me that again. Thank you.
Why haven't you started your own crew or gone and be your own subcontractor?
Okay.
Great teaching moment. Mom suggests dad should start his own crew. The judge shuts that down as not required by law. Family courts don't force someone to become an entrepreneur, invest capital, buy vehicles, tools, or take on business risk to hit a theoretical earning capacity. The standard is reasonable efforts within a person's experience and the real job market. If tile slowed and postings are at $15 to $20 per hour, courts often accept a lower wage absent proof of avoidance. For the audience, where's the line between reasonable job searching and strategic under-earning? What proof would you want to see?
Your own subcontractor.
Okay, ma'am. That's not a relevant question. I'm sorry.
Yes,
Yes,
he
ma'am.
has
He
has the experience and did exactly what his brother did.
Okay, ma'am. But he didn't have to go out and start his own company. You're talking about funds. I'm sorry. He's not obligated to go ahead and try to do something after he got laid off, as far as on his own. So I'm not sure how much money this gentleman has, but if you're going to start your company, you got to have vehicles, you got to have capital, you got to have you got to have some serious dollar to get something like that set up.
Which when we were together, we helped his brother start it. We did supply the money for the tools and stuff.
All right, then. Again, ma'am, again, it's your job here. I'm sorry, your testimony that you need to elicit from him is to show that he is intentionally underemployed, and not going out and doing something on his own and not starting something on his own under his own initiative is not going to prove underemployment, ma'am. So you have a question to show that you want to ask to show that he's intentionally underemployed. And again, I know you're not a lawyer, but that's the standard as far as Texas Family Code is concerned.
Your Honor, I don't know how to do this. They just said that he was not disabled, and so that there's no reason he couldn't find work.
Well, remember, he's got a job and he has work, and disability has not been a portion of any of this hearing, ma'am. No one has alleged that the father is disabled.
He's making half of what he was making, and then he quit paying child support entirely.
Okay, okay, ma'am. I'm sorry. That's why I gave you the opportunity to go out and hire a lawyer, ma'am, because you're not doing. I'm getting ready to end the hearing because, again, the information the court has at this point. The gentleman got laid off long before we came before child support review. He looked at his testimony. He looked for employment. He's retained employment. He makes $15 an hour now, but obviously, ma'am, he's not making as much as he used to. And he has, and his testimony is pretty much legitimate as to what that concern is. So at this time, ma'am, I can't find that he's intentionally underemployed. He doesn't have any special licenses. He doesn't have any special education for those that will allow him to turn his education into a thriving company or income. So at this point, ma'am, I'm looking at to just go with what the man's doing. He's working 40 hours a week at $15 an hour and earning child support based on that amount. And I'm getting ready to go ahead and end this one at this point because there's nothing else there.
Here, the judge shows their hand. No special licenses, no advanced education, a credible layoff story, and current full-time work at $15 an hour. Without concrete evidence of intent, like rejecting comparable offers, falsifying applications, or timed employment maneuvers, the court won't find intentional underemployment. Result: support set at guidelines based on $15 per hour. For editors, on screen, show a quick explainer. Guidelines equals percent of net resources times number of children, jurisdiction specific. Engagement prompt: if you were judge, would you impute his old $5,000 a month because of long trade history, or stick to the provable present?
Anyway, Mr. Welch, again, do you have any other questions at this point? Because again, right now, I don't see that the gentleman's underemployed. There's nothing here showing that he's intentionally underemployed. He doesn't work as he used to. He doesn't make as much money as he used to, but that's not illegal and that's not intentionally underemployment. So at this time, Mr. Welch, I'm going to allow, I'm going to stop the testimony, but I want to listen to closing statements and closing arguments. And if you've got a closing argument to show that this gentleman's underemployed, I'd like you to go ahead and tell the court that information, because I want you to go forward first, and then I'm going to go ahead and let Mom go next. But again, right now, I'm not seeing it.
Thank you, Your Honor. So, Your Honor, I don't have any argument like that. I would just ask the court to confirm the temporary order as final. Which it does the $15 an hour, 40 hours, per week, 52. It goes through that, Your Honor. So that's it, Your Honor.
Okay. Again, ma'am, I know this is a lot of legal mumbo jumbo to you, but the bottom line is disability doesn't have anything to do with it. His initiative has nothing to do with it. It has to do whether or not you can show that he's intentionally doing this job and to be underemployed to affect his child support. Do you have any other information, ma'am, to that effect?
I don't understand how the payments he's made or not paid doesn't show that. And I don't understand what the point in a court order is if he gets to pick and choose how and when he follows it, if he follows it at all. And even since all this in March, he has not been making payments on medical. It just doesn't matter what it says. He does what he wants, how he wants, and it affects my son.
Here's the deal, ma'am. The court order is the court order. If you bring me a motion for enforcement and you prove that he has not paid on the dates he was supposed to pay, then I will deal with it. But for right now, I don't have a motion for enforcement before me. If you do that, then I will go ahead and have a hearing on it. If I find he's violated the court order, I'll reduce things to judgment. I can even put him in jail. But the bottom line is, ma'am, I've got to have pleadings as such. All right. Again, this is the law's strict, and again, I know lay people don't get it. That's why law school is 3 years and exams and years of practice. But the bottom line is, no, ma'am, he doesn't get to do what he wants to do. He has to follow the court order. You got to follow the court order. If either of you do not follow the court order, and someone, either yourself as a pro se litigant representing yourself, or hire an attorney to do it, then the court to file the necessary motions. I will have the necessary hearings on it, and I will make the necessary orders, which will include finding judgment, ordering repayment, and possibly a jail time. All right.
Your Honor, my understanding is that's already been handled, and that his fine is just $100 a month for the back child support.
No, ma'am, that's not been handled. That your understanding is incorrect. I have not had. There's nothing in this file to show that there's been a hearing on enforcement, ma'am. And we don't. I don't do fines. So I do jail time.
Yes, Your Honor.
Okay. All right, ma'am. I'm going to go ahead at this time, and again, I cannot find underemployment. I'm going to go ahead and keep the temporary order as is. The $15 an hour is what the gentleman's been earning for almost the last year. So at this time, I'm going to go ahead and order that. I'll reduce the judgment on both the unpaid child support and unpaid cash medical order repayment as requested in the temporary order. My understanding is that I made everything in that temporary order a final order anyway. So it's just going to be reiterated that that's the final order of the court. And the new order is that the child support is set at the guideline amount based on $15 an hour going forward. Is there anything else, Mr. Welch?
No, Your Honor. Nope. Yeah, like I said, Your Honor, temporary order already has that, the $15 an hour. I think we're good to go.
All right, Mr. Halden, questions or anything else, sir?
No, sir.
Okay. All right, ma'am, any questions or anything else?
No, Your Honor.
Okay. All right, Ms. Haldeman, follow the court order, sir.
Yes,
Pay
sir.
you pay on time. Otherwise, if you're going to end up before me on that enforcement, I will deal with it. And,
Yes, sir.
ma'am, same thing with you. As far as anything in that order concerning your obligations to him and the child, and would allow him to do things with the child, please follow it. Because again, all those items are enforceable. But this time, I'm going to go ahead and have the state prepare that order, and I'm going to waive court costs on this one, Mr. Welch. All right.
Oh, all right.
All right. Thank you. All right. Thank you both very much. We're off the record.
Thank you, Your Honor.
Thank you, Your Honor. So Ms. Haltman, Mr. Haltman, I'm going to send the order through DocuSign for you two to have a chance to sign. Probably give you a couple days. The only thing I'll be changing was, waiving the court cost, and that's it.
Thank you, sir.
All right. We're done. Y'all can leave.
Thank you.
And Your Honor, I guess for you, just letting you know for the next cases, there's one case at 115, Miss Taylor.
Right.
You're good, Miss Haldeman. You can leave. This is just about other cases.
All right, go ahead, Mr. Welch.
So yeah, the next case is at 115, and that's with Miss Laura Taylor. And then I've got the case after it at 3:00. However, I will be talking with the parties and Mr. Brimhall.
Summary. The court finalized the temporary terms. Child support calculated from $15 per hour, 40 hours per week, with prior cash, medical child support judgments reiterated. The judge emphasized enforcement is a separate path, bring a proper motion, prove missed payments, and consequences can range from judgments to jail time. On underemployment, the ruling hinged on proof. No licenses, no vocational edge, no hard evidence of avoidance, so no finding of intentional underemployment. Takeaway: feelings and screenshots don't win, admissible documents do. If you found this case as shocking as we did, make sure to hit like, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Your support helps us keep decoding real court drama with real legal insight.